In this week's module, we will conclude our examination of the issues relating to the terms of a contract by focusing on one final topic, the parole evidence rule. The rule applies to all contracts governed by both the common law and the UCC Article 2. As a result, the parole evidence rule tends to come up on the bar exam, but the doctrine is notoriously nuanced and intricate, and so students tend to naturally confuse when and how to apply it. You likely remember the parole evidence rule from your study of the common law of contracts. And after that experience, you may have been hoping to forget it for good. My goal after this week's module is that you feel confident that you have mastered the purpose and application of the parole evidence rule, both for this course and for the bar exam. As we consider the parole evidence rule, this will serve as our roadmap for this week. But before we delve into the details of the rule, let's start with a high-level overview, an overview that starts with a simple example. Imagine a transaction involving the sale of a motorbike. The seller sells the buyer the motorbike, something that is clearly a good, and the parties document their transaction with a written agreement. The written agreement says that the seller will sell the motorbike to the buyer for $500, but imagine that in the discussions leading up to the execution of the written agreement, the seller also told the buyer that this model of bike is extremely reliable and will not require any repairs or maintenance for years. And that assurance by the seller was a material basis for the buyer's decision to purchase the bike. Thus, by any standard, the seller's assurance was a basis of the parties' bargain. Stated differently, under Section 313 of Article 2, the sellers made an express warranty to the buyer. But the written agreements that the parties signed does not mention anything about that warranty. That's true even though the express warranty was a part of the parties' actual agreement. It was a part of their bargain in fact. The written agreement does not mention anything about an express warranty, and this could happen for all sorts of reasons. Maybe the parties were using a standard form sales contract, a form that they neglected to customize with the specifics of their deal. Or maybe the buyer thought that it was unnecessary to incorporate the express warranty into their written agreement. It was unnecessary because the buyer expected that the seller would stand behind her words. Or maybe the seller didn't think that she was actually bound to any kind of warranty, that what she said was just talk, that the written agreement is what the parties are actually bound to. Whatever may be the case, what we have now is called a parole term, a term that one party alleges was part of the party's contract, but that is extrinsic to the writing. By extrinsic, I mean that the contract term is not found in the party's written agreement. Instead, the term was agreed to outside of the writing, most commonly a term that was something that the parties agreed to orally. Assume now that 4 weeks later, the bike's gears get jammed and the buyer wants to return the bike to the seller for repair or a refund. But the seller says there is no warranty on this bike. It was sold as is. Look at the written agreement. There is no mention of any warranty. Who is right? This is the kind of question that is answered by the parole evidence rule. One preliminary note before we get too far, it's spelled parole, not parole with an E. It's not what you get for being good in prison. Parole here means oral. But the parole evidence rule applies to all extrinsic evidence, any evidence extrinsic to the written agreement, any evidence that is not the writing itself. So the parole evidence rule covers all extrinsic evidence of all prior or contemporaneous agreements or understandings between the parties, whether written or oral. That could include evidence in the form of witness testimony, testimony by one contract party claiming that there were additional agreements or understandings between the parties beyond what was reflected in the parties' written agreement. But it also includes documentary evidence, emails, texts, or other memoranda exchanged during the negotiation process that would show that there were additional agreements or understandings between the parties beyond what was reflected in the parties' written agreement. Finally, extrinsic evidence also includes course of dealings or usage of trade, which we know the UCC says can add to or supplement the parties' written agreement. So, what is the parole evidence rule? It is a substantive rule of contract law, a substantive rule with evidentiary consequences. Here's how I like to think about it. First, the parole evidence rule is a substantive rule of contract law. That's true both under the common law and the UCC. That substantive rule of contract law provides that when parties reduce their agreement to writing or a record in the language of the UCC, then all prior agreements and understandings relating to the subject matter covered by the written agreement or record are superseded or discharged. At that point, once the parties have reduced their agreement to writing, what the parties are bound to is what is in their writing, not anything else that they may have said or agreed to prior to the adoption of the writing. But the substantive rule of contract law also has evidentiary consequences. When the parties reduce their agreement to a writing or record, the parole evidence rule bars all extrinsic evidence of any prior or contemporaneous agreements or understandings that would contradict the written agreement, that is, conflict with the terms of the written agreement itself, or supplement the written agreement with additional terms, terms that go beyond what the written agreement specifies. Press pause now and take a moment to reread these two principles, just to make sure you fully appreciate the scope and the function of the parole evidence rule. Another preliminary point that we can make now is that the parole evidence rule applies only to prior or contemporaneous agreements between the parties, agreements or understandings that the parties may have had prior to or contemporaneous with their written agreement. By implication, this means that the parole evidence rule does not affect any subsequent agreements between the parties, agreements reached by the parties after they had made their written agreement. As we have noted before, contract law permits parties to freely modify their existing contracts if the intent to modify is mutual. Stated differently, the freedom of contract includes the freedom for contract parties to redo or modify their existing agreements. Consequently, extrinsic evidence of any subsequent agreements between the parties is not subject to the parole evidence rule. Thus, to revisit our discussion of contract modifications, a subsequent course of performance between the parties that deviates from the parties' written agreements can operate as an implied modification of the parties' written contract. The parties' objective manifestation of mutual assent to the modification is implied through their conduct. Extrinsic evidence of a subsequent course of performance is never barred by the parole evidence rule, though, as we'll note later, such evidence may be barred by a nom clause in the parties' written agreement. So that covers the very basics of the parole evidence rule, though at this point, you might be reasonably wondering what is the rationale or purpose of the rule. After all, once you have an appreciation of the rationale or policy behind any legal rule, it aids in your understanding of the rule and its application. There are several policy rationales that have been articulated to justify the parole evidence rule. For one, it favors the enforceability of written agreements over oral agreements. The rationale is that when parties reduce their agreements to writing, they tend to be more serious, more deliberative about what they are agreeing to. People may speak off the cuff, engage in all sorts of loose talk, but when they write something down, they really mean what they're writing. So when the parties to an agreement commit their agreement to writing, the parties intend the writing to incorporate the final and complete expression of what they agreed to. The writing would therefore supersede any previous discussion, understanding, or negotiation between the parties regarding the subject matter covered by the written agreement. All that preceded was just talk. What's in the writing is what the parties actually intend to be bound to. Dovetailing this policy is another rationale that the parole evidence rule promotes predictability and certainty for contract parties. The parole evidence rule allows contract parties to rely on written agreements without having to worry that they may be bound to other terms, that is, parole terms that were not included in the writing. Again, what's in the writing is what the parties are bound to, not some ethereal other terms that are beyond the writing. Finally, as the name implies, the parole evidence rule also has an evidentiary justification, that written evidence of an agreement is better than human memory. Human memories fade and are inexact. Writing is more durable and concrete. Even if that writing is in electronic form, an email, Word document, or text message, all of which would be included in the definition of a record under the UCC. Thus, the parole evidence rule protects against fraud and the enforcement of false agreements. Specifically, it protects against one party later alleging that the party's actual agreement was something different than what their written agreement specifies. Think about it for a moment. What does this final policy rationale remind you of? Recall, this is the same rationale behind the statute of frauds. And like the statute of frauds, courts have voiced similar concerns about the parole evidence rule, namely, that the rigid application of the parole evidence rule may cause more harm than good. Like the statute of frauds, the parole evidence rule may preclude the admission of extrinsic evidence suggesting that the parties' actual agreement included additional or different terms, terms that are in addition to or in conflict with the party's written agreement, terms that were in fact never agreed to. But also, like the statute of frauds, the parole evidence rule may prevent the admission of extrinsic evidence showing that there were, in fact, parole terms to the party's contract, terms that the parties actually agreed to, but for whatever reason failed to include in their written agreement, which is not an implausible scenario. It requires only a moment's reflection to appreciate that two individuals, two parties to a contract, may have all sorts of understandings or agreements, and it's impractical, indeed impossible, to expect contract parties to write everything down that they may agree to write down every understanding or expectation that they might share. And the whole purpose of contract law is to enforce agreements, what the parties actually intended to be bound to, not pieces of paper with words on them. So, like the statute of frauds, blind deference to the parole evidence rule risks undermining the foundations of contract law. At this point, it might be helpful to be more explicit about the relationship between the parole evidence rule and the statute of frauds. Both doctrines reflect the legal preference in favor of written agreements over oral agreements. But the statute of frauds is all about enforceability. It says that certain kinds of oral agreements are simply unenforceable if there is not adequate writing or an applicable exception to the writing requirement. By contrast, the parole evidence rule is all about interpretation and the evidentiary consequences that follow. When can we use extrinsic evidence to supplement or contradict the terms of a written agreement? But like the statute of frauds, even if the parole evidence rule doesn't bar the admission of extrinsic evidence, that is, even if parole evidence is found to be admissible, that only means that the party alleging the parole term may present the extrinsic evidence to the ultimate fact finder at trial. The party asserting the parole term still bears the burden of persuasion to persuade the fact finder, the jury, or a judge in a bench trial that the parole term was in fact actually agreed to. So that concludes our introduction to the parole evidence rule. In the next two videos, we will delve into the rich details of the rule.